Good afternoon. I would like to speak with you about your rights to work at hire. No person shall be deprived of life, liberty, or property without the due process of law. The right of a person to work shall not be denied or abridged on account of membership or non-membership of any labor union or labor organization. This statement is taken from the South Dakota Constitution, Article 6, subsection 2, titled Due Process, Right to Work, which was approved in 1946. This is followed by a multitude of codified laws which examine and evaluate each area which may be debated as interference of employment. Therefore, I encourage you to understand some of the meanings of your rights to work at hire. Right to work laws protect against coercion. At-will employment incorporates all involved, and terminations are valid. 43 states enforce the right to work laws existing on one similar definition, the Due Process Clause. The subsections which follow state in the article of the Constitution, and it focuses on the definition of the right to work or right to work states. The definition interprets the legal stance when dealing primarily with labor forces or labor unions. Right to work laws protect against coercion. The National Right to Work League, or Legal Defense Foundation Incorporated, outlines the key elements of labor and employment chapter in the South Dakota Constitution, identifying a multitude of subsections. For today, I briefly want to discuss the areas of interference of employment via the labor disputes in the legal boundaries. The definition of right to work is very misunderstood. The formation of the term was established in the 1940s. It is to protect people against the due process and the ability to work without being coerced. It is applicable to the regulations of the labor unions and forces. Labor unions were established to protect the employees from mistreatment of the employer during difficult times. Over history, the union bosses became intimidating. The employees became filled with fear. The unions demanded dues and fees, allocated those monies for distribution of power to politicians or entities that coerced when they did not confer with the union members. Therefore, right to work was established, and now again is to protect the employee from a mistreatment of an employer in difficult times. Now that I have briefly summarized the right to work laws, I would like to familiarize you with the alternative, at-will employment. Do you know what type of entity you work at? Do you know in your handbook where that simple little answer is? At-will employment incorporates all involved. My experience is the larger the company, the thicker the paperwork. Prior to this speech, I did not know what type of entity I worked for. Did my research, and I found the statement, not realizing I'd even read it or where it was at. Most employee handbooks or some piece of paper that you sign has a phrase stating, Acme Company is an at-will employer or agency. This clause or paragraph is usually one of the very first things presented to you, way before the bylaws and those vacation days they're going to give you for being such an on-time and good employee. No matter how everything else is stacked, that one written statement carries all the weight. According to John Paulson, who is an attorney in California, he is an employment lawyer. He stated in an interview in the New York Times, in an article stating, or titled, "One Key to Problem-Free Firing is Dignity." The statement says a common law rule in an employment contract of indefinite duration can be terminated by either the employer or the employee at any time for any reason, also known as terminable at will. The design and enforcement of that one statement, combined with the discrimination clause, has been the protectors under state and federal laws and kept within certain guidelines. Those guidelines I refer to are it is illegal to fire a person due to race, religion, age, or country of origin. A number of states also incorporate additional clauses of sexual orientation, medical condition, or in the regards of a company whistleblower. With this in mind, many may find any terminable cause for any issue. Now that I have reviewed the basics of a right to work and at-will employment states and the general guidelines, I would like to address the responsibility you have at hire. The majority of terminations are valid. My third point will discuss termination and the validity. Public knowledge that employment rates are at extremes. It has become an everyday topic. Although unemployment, the rate fell to 8.2% from 8.3% in February of 2012. 7,000 construction workers were laid off in February alone. This was from MSNBC.com on Saturday evening. From my past experience in just the last year, unemployment claims are not a given. One day you may be praised for your work, and the next day you may be terminated. Unemployment is not a given. A view of Sheriff Fred Lamphere for the Butte County Law Enforcement Team, who was interviewed in April of 2012 in reference to this topic and his professional opinion. The guidelines of his handbook established for Butte County, South Dakota, and he states, an at-will and at-right to work state, such as South Dakota, limits the complacency of a workplace. The level of stress in his departments can contribute to negative burnout. Therefore, he acknowledged the rationale of empathy is vital and the function of a workplace environment. Everyone has to remain accountable. This entails not only the employee, but also the employer at any time. They may be terminated on either side. The employee should be encouraged to challenge the fine line of the position prior to hire. Lamphere also referred to the unemployment claims in the labor board. He states that most unemployment claims and termination in his departments are not paid out. The policy and procedures in his county are ironclad. There's no room for mistake. Other articles that I will discuss: Fired Workers, Fire Back, and Fall Hard, written by Walsh and published in the New York Times in 2001. It discusses workplace arbitration, and it has been very controversial of late, with most employers require workers to settle disputes. This refers to notification and the obligation of no clause. In the first case, arbitration, barriers that employees face during arbitration during determination litigation are not only lengthy, but very expensive. Most companies have designed their policies and procedures to protect all involved, but foremost, the company will protect themselves and their stockholders. Other significant barriers may still be the conflicts of interest and the underwritten black marks that will remain on your termination. During any other termination, if it is inevitable for the employee, the ability to fire with dignity is a suggestion. To minimize the further acts of litigation or bad press, to fire with dignity may be as simple as offering a review from another management team member and not the direct supervisor, offering positives for the employee's reference letter. Facts of termination, unless illegal, do not have to be public knowledge. In conclusion, I would like to ask for you to look at the ability of a person's right to maintain work should not be denied, should not be intimidated or misunderstood by silly contracts or phrases. The understanding of right to work versus an at-will employment should be explained at the interview or with the policy changes as the workplace changes. When faced with the misfortune of a termination, expiration, or a resignation of any employment, all parties should consider the areas of confidentiality, dignity, and accountability. I persuade each one of you to always inquire and hire, to understand your rights at hire. Right to work laws protect against coercion. At will doesn't incorporate all involved, and the majority of terminations are valid.